Imagine losing everything you've built, not because you made bad decisions, but because someone else sued you and a judge agreed. Meanwhile, the billionaire down the street, he doesn't lose a dime. Why? Because he used legal shields that many people have never heard of. Hi, I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. And for 34 years, I've helped protect high net worth individuals, business owners, and real estate investors from lawsuits, divorce, and financial predators. And my firm has set up more Cook Islands trusts than any organization in the world. And for good reason. When you learn how the ultra wealthy protect their empires, it'll change how you see your own financial security. So if you're serious about preserving what you've worked so hard for, hit that subscribe button if you haven't. This isn't theory. This is what the mega wealthy actually do to protect what they built. And yes, you can do it too. Let's dive in. First of all, here's why regular asset protection fails and what the wealthy already know. Now, I'm sure you've heard of LLCs, insurance policies, and maybe even living trusts, but here's the truth. These tools alone won't cut it against a determined creditor or an aggressive attorney. So let me paint the picture. A business owner in Texas was hit with a $9.7 million judgment. He had multiple LLCs. Still, the court pierced the corporate veil and went after his personal assets. Why? Because he treated the LLC like his personal piggy bank. The ultra wealthy, they don't make the same mistake. They use layered structures across multiple jurisdictions, some of which make it nearly impossible for a judge in the U.S. to seize assets. So here comes the first shield. We'll call this section the Offshore Trust, the Titanium Vault. Now, let me talk about the Cook Islands Trust, the Belize Trust, and the Nevis Trust. Now, Cook Islands is located in the South Pacific, south of Hawaii. Belize is an English-speaking country in Central America, and Nevis is in the Caribbean, just southeast of Florida. Now, these are not your average living trusts. They're fortresses. In fact, Cook Islands is our go-to because it has the longest case law history. Belize is often our go-to if you're already in a lawsuit, because the Cook Islands is often hesitant if you're already in a lawsuit and the bullets are flying. Now, Nevis is the alternative, so we have a third option if needed. Now, for now, let's focus on the Cook Islands Trust and what makes it so powerful. Located in the South Pacific, the Cook Islands does not recognize U.S. court judgments. It protects assets the moment you put assets into the trust, and the statute of limitations on fraudulent conveyance is just 1 to 2 years. So once the assets are there, it's game over for most creditors. Now, trust structure requires a licensed bonded trustee, but here's the secret. We nest a Cook Islands LLC, this offshore trust here, inside of the trust, and you initially manage that LLC. So you control the assets, you're the signatory on the bank account, you trade stocks and so on, until the legal fire rains down. At that point, our licensed bonded trustee company law firm steps in, shielding your wealth because U.S. courts don't have jurisdiction over our Cook Islands trustee law firm. In fact, I've been setting these up for nearly 30 years in the Cook Islands. Like I said, I've set up more of them than anybody in the world. So want to know what this looks like in real life? You'll love the next section. Now, here's a case study, the doctor who couldn't be touched. One of our clients was a surgeon, mid-50s, worth about $8 million. He was being targeted by a former patient with a long history of lawsuits. So like we mentioned before, we set up an asset protection trust in the Cook Islands. So it's a Cook Islands trust with a Cook Islands LLC inside of it. And we layered it with a U.S. LLC under it to hold his real estate. So each piece of real estate was in a separate land trust for privacy of ownership, home in a land trust, and for the rental properties, we made an LLC the beneficiary of each of those land trusts. And all of these LLCs here were owned and managed by a Wyoming LLC for privacy with a nominee manager and a virtual office in Wyoming. We recorded mortgages against each of the properties. We call this equity stripping, and that was payable to his Cook Islands LLC. And then eventually we got a third-party lender to buy those mortgages, and we placed the proceeds for those mortgages over here in the offshore trust. So when the lawsuit came, the plaintiff's attorney thought that he had struck gold. But when he discovered the offshore trust, the liens, the jurisdictional wall, he backed off. Lawsuit dropped, no settlement paid. It wasn't luck, it was legal architecture. So let's take that architecture deeper. So I call this section multi-jurisdictional defense, how billionaires build moats. Now, the ultra-wealthy don't just protect their wealth in one place, they spread it. They might have a Delaware or Wyoming LLC for domestic operations for running their business, a Nevis LLC for offshore strength, a Cook Islands Trust to anchor the whole structure, a Swiss or a Liechtenstein bank account, layered UCC1 liens filed against domestic structures, such as the private stock they own, cars, yachts, planes, and so on. And those UCC1 liens are payable to the offshore LLC that's inside the Cook Islands Trust. They don't use their names. Assets are titled in land trusts and LLCs. Those LLCs are owned by the trust, and their homes have mortgages. Even if they own them free and clear, they have liens payable to their own LLCs with a third-party lender waiting in the wings to buy those mortgages to put the proceeds offshore. So why do we do that? Because lawsuits don't target debt. They target equity. And you've taken out all the equity, there's really nothing left to take. So here's the cliffhanger. What happens in the event this structure isn't enough? We'll answer that in a moment. But first, let's talk about something that most people overlook entirely: privacy, the first layer of defense. Now, if they can't find it, it's pretty hard to sue for it. So privacy is one of the most underutilized legal shields. So that's why the wealthy use land trusts, anonymous LLCs, nominee service, and third-party lien holders to keep their name off of the public records. For example, let's say your primary residence is titled in your name. A quick Google search and a lawsuit later, and you're fighting to keep your home. But if your home is titled to a land trust with a mortgage lien recorded in favor of an offshore LLC inside of your Cook Islands Trust, and then if needed, we arrange for the third-party lender to go in there and buy the mortgage and put the proceeds into your offshore trust, now that same lawsuit hits a wall of paperwork, jurisdictional firewalls, and layers of ambiguity. So here's the trap most people fall into. They wait until they're sued, which brings us to the next point. Timing is everything, and the clock is ticking. Now, the worst time to set up a legal shield is after the missiles are in the air. Courts scrutinize transfers made after you're sued, or if you know a lawsuit's on the way, or you're threatened with litigation. So that's why timing is critical. Once you're in legal hot water, many domestic tools lose their power, or worse, backfire. So the mega wealthy don't wait. They build first, defend always. In fact, our law firm helps clients get protected before trouble shows up. And when it does, these structures are already in place. Now, we can set it up after a lawsuit, but it's better to set it up before because it'll be a stronger structure and it will also cost you less. But what about U.S. judges? Can they compel you to bring back offshore assets? So let's go ahead and answer that head on next. We call this section the legal reality. Can a judge force you to repatriate your funds? And the short answer, no, not if it's structured properly. So we have this bank account here. It's in the offshore LLC and your offshore trust. If needed, your trustee company, a law firm, steps in as manager of the LLC. The judge says, give me the money. And you say, sorry, I have to ask the trustee. The trustee says, no, we are obligated to protect our client and you don't have jurisdiction here, Mr. Judge. So that's why our trusts are drafted, so that once legal duress hits, you can no longer directly comply with the judge's orders to bring back the assets. So only the independent offshore trustee company law firm can make that decision. And like I say, they're the most highly regulated industry in the world, the Cook Islands trustees, as well as Belize and Nevis, and their duty is to protect you and protect the trust. So courts can demand, but if you don't have the legal authority, you legally can't comply. And that's what makes offshore asset protection so powerful. In fact, we've used this strategy to protect clients from everything from frivolous lawsuits to government overreach. So now for the bombshell, the trigger trust, when domestic and offshore combine. So the trigger trust is our registered trademark. We're the only one that can legally set these up. We've trademarked it. So some clients ask, can I keep everything domestic for now, but still be protected later? And the answer is yes, you can use what we call the trigger trust, our registered trademark, and here's how it works. We start by setting up a domestic trust for our clients. So the structure includes language allowing conversion to a Cook Islands trust when a threat arises. So the assets are already pre-positioned, so you're not scrambling post-lawsuit. So this gives you flexibility and power. So the trigger trust lets you live in peacetime with full control, then switch to wartime footing instantly when you need it. So it's like the legal equivalent of a bunker under your house. You still with me? Good. So let's break down the top myths that you've heard. We call this section Myths About Wealth Protection Busted. Now, myth number one is only billionaires need this. Nope. Our typical client has between 1 million, 25 million in assets. You don't need a Gulf Stream, you need protection. I mean, think about it. If somebody has $2 billion and they're sued for $1 million, it's not going to change their lifestyle if they lose that lawsuit. But if somebody only has 900,000 or $1 million or $1.2 million and they get sued for $1 million, well, that's going to rock their world. So who needs the asset protection more? Myth number two, it's shady or illegal. Well, everything we do is 100% legal and compliant. Like I said, I've been doing this for 34 years and I'm still standing. These are legitimate tools used by the world's top attorneys and advisors. Myth number three, my insurance will cover it. Until it doesn't. Exclusions, limits, and claim denials are real. I mean, insurance is not going to protect you against a divorce, and they don't stop a plaintiff from freezing your accounts. Myth number four, it's too expensive. Well, it's a whole lot more affordable than you think, and losing your assets, far more costly. Myth number five, I'll do it later. Well, statutes of limitations, fraudulent transfer claims, and timing are all working against the procrastinators. The best time was yesterday, and the second best time today. So final section, final takeaways, and your next step. So the legal shields of the mega wealthy aren't magic. They're methodical, intentional, strategic. They use Cook Islands trusts for bulletproof protection with Belize and Nevis as alternatives. Offshore LLCs, they control until they shouldn't. Land trusts for privacy, equity stripping, and UCC1 liens remove the value from creditors. Trigger trusts for flexibility, so you have a U.S. trust initially and an offshore trust when you need it. Multiple jurisdictions to stay ahead of threats. And with 34 years in the field and nearly 30 of those setting up Cook Islands Trust, my team and I at Lawyers Limited, our law firm and asset protection planners, know how to build these structures to withstand the storm. So here's your action step. Go to assetprotectionplanners.com. Fill out the contact form if you're serious and not curious. If you have $500,000 of assets or more to protect, let's build your moat before somebody lights the fuse. So thanks for watching. I'm the business guy, and I'll see you in the next one.